Thank you, and good to see so many in the room. Obviously wanting to start by acknowledging the Wirandjuri people, recognising that the spirits of their ancestors rest on the country which we are standing today. Also acknowledge Uncle Herb for his welcome this morning. And a special shout out for the commissioners from URUK. There's been a huge amount of support, both publicly and privately, from URUK. On some of the most challenging days, I'd come home and I'd have a text from Travis, making sure it kept the fire going. So that's really important. Now, what we wanted to do was to talk in three things, and a bit of a behind the scenes, right? Ivan and I are unemployed at the moment, so we don't have any obligations. We can tell you, we're refusing to talk to the media, but we can tell you the behind the scenes of the journey over the last 6 months. And three parts. So firstly, I want to talk to you a bit about just the background of getting the inquiry started and some of the key things that I think you need to think about if you're looking at doing a similar model in your state. Ivan in particular will talk about our practice guidelines and how we dealt with developing processes which were really key to the community, engaging with the community. And then we want to give you the last month of exactly what happened. So it's a really interesting story. And look, we obviously want to keep it conversational as well. A little bit, a different model in Queensland, and my preference, having gone through this model, I'll talk to it, is the Royal Commission model. I think it was a failing in Queensland not to have a Royal Commission model. There were 5 or 6 years of consultation, and a number of different consultation bodies were established in the lead up to what was ultimately the Path to Treaty Act. And the Path to Treaty Act established both the Treaty Institute and the Truth Telling and Healing Inquiry. And I wasn't involved in any of those consultations, but I think the feedback which the department and the government really ran with was Aboriginal and Torres Strait Islander people didn't want a really legalistic model. But Travis touched on it, you need to have the legal model, but your processes can be in a less formal way, which I think is a better method. And I'll just talk to that point. I think a Royal Commission could have got stood up quicker in Queensland. Also would have had a lot stronger legal processes, and the Path to Treaty Act had some mix between a Royal Commission type model and a consultation type inquiry process. So we didn't have protections and immunities to the same level that commissioners have. We had some, but not all of them. Under the Path to Treaty Act, as I say, the inquiry got stood up for 3 years. Now, interesting coming into that role, and I think there was 3 things for me in that leadership position which really stand out. And if you are going to replicate this in your state, it's important to think about these things. Firstly, having a vision when I came into the role about what the inquiry could achieve. It was obvious from the lead up to the election that the inquiry was at risk if the LNP government were successful. So I had to really develop a vision around what I thought the inquiry could achieve in the lead up to the election. But I also came in with a vision of, I knew from the start what were the 9 or 10 parts of the final report that we should be looking at. And so when I stepped into the hot seat on 1 July, I already had thought about those 2 things. And I thought key in terms of the vision in lead up to the election, although I guess there's 2 other things. There's the team, there's a vision and the strategy, and they're all very fundamental to each other. But part of the vision and the strategy was to ensure that we did not make the same mistakes as the Voice, in that I wanted all people in Queensland to understand exactly what the inquiry was. There wasn't going to be any, we didn't know, we didn't engage, we didn't hear from them, even in the short time we had in the lead up to the election. Now, team is critical as well on that point, and my motto in my work for the last 14 years has been, as a barrister, has been, if I'm not pissing people off, I'm not doing my job properly. Because I'm not there to make friends, I'm there to get a job done. I'm not a politician. And so I had to make tough decisions around I had to move people on. We had to change our teams at various points. Fortunate, and I do want to give a shout out to Em from KWM, chipped in and gave us a huge amount of support when we needed it. But having the right team to deliver the vision and the strategy is actually really critical. And it's the first time I've had to fire people, but we built up a really strong culture, and we had a great team who were prepared to really get in the trenches and do the hard work despite the limitations. And I want to acknowledge that, because a lot of the people who came on board left really good roles, on the basis they knew that we were coming into the election, but this is something they really wanted to be involved in. And so, knowing those risks, it was a really, really important thing that people made that commitment. And the strategy, and I've talked a little bit about this, and this is where leadership comes in. And I just want you to think about over the last month what you've heard. And as I said, under the Path to Treaty Act, both the Treaty Institute and led by the Treaty Council were established, and the Truth-Telling Healing Inquiry. What I wanted, that strategy, that vision I had, wanted to make sure all Queenslanders were engaged, all Queenslanders understood, was completely different to what the Treaty Institute did. They did almost nothing in that time. And so all the sort of stuff we've heard over the last month, and even the politicians, was, we need to keep the inquiry. Don't think those things happen organically, right? So, and this is what as young lawyers, what you really need to understand, you don't win cases based on how well you drafted a document or how well you drafted a letter. You win cases on strategy. And right from the start, I had a really clear strategy in mind. Yes, the government could always win. They could always get rid of the inquiry. But I wanted everybody to know what they'd be missing if that inquiry went. And I think we achieved that. And that's all part of the strategy. Now, those are probably some of the three fundamental things before I switch to Ivan and talk about our processes, and then I'll come back and talk about that last month.
Yeah. Thank you, Josh. I'd just like to acknowledge Uncle Herb for that fantastic welcome and that performance. That was quite amazing. Acknowledge country that we're on, elders past and present, and particularly last night's recognition of Black excellence. I'd really like to shout out and acknowledge that we're amongst great company here. Thank you. I also want to acknowledge the URIC Justice Commission and the Chair and Deputy Chair who've come today. They have provided both formal and informal advice to our team across our short tenure. It's been really great to have another cohort of people who've gone through and pioneered a way for what truth-telling may look like across the country. So thank you for your help and support. It's been quite a ride over the last 5 months. I'll talk a little bit about what we were able to achieve, what we were able to do over that period in developing our processes, in how we were going to deliver an inquiry across the 3 years. So part of it will be a bit abstract of what we wanted to do. Some of it was enlivened in our first hearings and sessions, but it provides a bit of a framework and some learnings if you wanted to take from what we say is some of the best practices in engaging with community, supporting people through processes that are quite legalistic but intended to be as safe and as culturally accessible as possible. So I might just touch on what the functions and objectives were required of us under the Act and under our terms of reference to give a bit of a framework of discussion, and then how we were able to realise that in some of our processes. So under the Act, we were required to conduct inquiries and document the individual familial, cultural and societal impacts of colonisation. We were to do that by conducting truth-telling hearings. They're the more formal sessions where the chair and myself and the other members would sit in a formal hearing setting. That's probably the high watermark of formality and in legal processes. We could also conduct truth-telling sessions. That only required at least one member to convene a session, and these could be much more informal in the way that we conduct the gathering of testimony from participants. So Travis touched on, being able to go out by a riverbed or in someone's home. That provided a similar type of flexibility for us to be able to do that in different situations and in different settings that's most accessible for participants. And like all other inquiries or commissions, receipt of submissions, and that could be quite broad of written text, video evidence, or other kinds of material provided. We also had a really important function around raising awareness and understanding of Queensland's history. So that's the public education function that we had. So while documenting and recording the history, we also had the important function of educating all of Queensland about that true picture of what our history was. and then ultimately provide advice and recommendations to the Minister. Our terms of reference, which specify the types of subject matter and how we were to conduct this work, is spelt out in particular clause 5 of our terms of reference. There are 5 broad categories of areas that we were required to look into. Those are, broadly speaking, land and resources, personal and familial autonomy, economic participation and control, state systems and services, and cultural and societal impact. We were required to look at the role of government and non-government in the colonisation of Queensland, the implementation of laws, policies and other actions. We were also required to look at the role of faith-based organisations and look at the contemporary and ongoing systemic impacts and barriers for the full participation of First Nations Queenslanders in Queensland life. In terms of enlivening the way that we wanted to do our work, we were required under the Act to provide support for participants before, during and after so that they're carried through as safely as possible. So we really looked hard at the way that we wanted to develop our practice notes, our guidelines for how people wanted to participate so that they were trauma aware, healing informed and culturally responsive. So we didn't just have our legal team, our lawyers and barristers create these practice notes and guidelines. We also had our community participation support team, our cultural advisors, our counsellors and psychologists look at all of the work that we were doing, the guidelines and how we would engage so that they were as informed and well-rounded as possible.
You got another mic there? Oh, okay. I did want to just say something on that before we go back to it, that having worked on those stolen wages cases and the stolen gen case and over the last 10 years and even Palm Island, really the model that we had implemented and we're utilising from my experience was best practice. Working on the stolen gen case is a really good example in the Northern Territory. All those cases really touch on the same traumatic experiences that would come before the inquiry. But having, and Ivan will speak to it, but actually having social workers embedded in your team, actually having the wraparound support after witnesses, you often do feel like in cases that, although, some of those witnesses in WA and the Kimberleys, I've spent 5 years working with them, you do feel like after a while, your evidence and you don't get to see them again. And you're sitting down and you're talking about these really traumatic events and you don't always have the right support. So it's really showed me, we run these class actions and everyone charges $25 million, but it'd be good if we could have some social workers embedded in our team because it would make a real difference.
Yeah. And that was really a key aspect of our engagement with community. And when we engage with individuals wanting to give their evidence, it wasn't just a lawyer doing the interview. There was also community support persons who are First Nations. We have a social and emotional wellbeing officer, either in-house or one of our external counsellors, to go out and provide that support to witnesses who wanted to come forward. And the way that we designed our engagements and how we were initially leading into working with our first community, Cherbourg, to kick off how that was going to roll out, we spent quite some time consulting with local council, local elder groups, local organisations to design how the community want to come together and share their story. That involved engaging in local services to provide that wraparound support and the continuity of care after we had finished working with the community for those sessions. So it was really important that we had in mind free, prior and informed consent, trauma-aware healing-informed practices, and the way that we safely enter in and depart from community, knowing that we're just a small part of a longer journey that people will be sharing their story. And at this early stage, we had a number of people ready to come forward, but we know that not everyone was ready at that point. So truth-telling will be hopefully an ongoing journey for Queensland, even though that the inquiry is no longer there. It sparked some interest in those communities who are ready to do local truth-telling exercises. And we just hope that this has started a bit of a movement for us in Queensland. I might just leave it there.
Yeah. But, what we were able to achieve in a short time, and this is part of the strategy, and so that, as I say, work done over 6 years in the lead up to the Path to Treaty Act. When I got in the hot seat, the department said, well, we've estimated a 12-month establishment phase, and literally threw that out the window So no, we did it in 8 weeks, and that includes building a team from zero. And in that time, we were able to have, obviously, our opening ceremony, our ceremonial opening, and I want to acknowledge the York commissioners who attended. We had 1,000 people in the room that day, and I think our biggest clap was for the York commissioners showing their support and solidarity. We also were able to have hearings of a number of lived experience witnesses, and there was some strategy again around that. We needed to get witnesses, because of our issues around free, prior, informed consent, Indigenous data sovereignty. We wanted to get witnesses that we could get prepared relatively quickly, and I mean quickly in terms of still took eight meetings, 8 conferences to prepare them over the course of a couple of months. But we were able to have that lived experience evidence, and we also had exercised our powers in respect to the role of government. We requested them to provide us with a number of documents, and we had a government truth-telling session where we had 6 Director Generals and the Commissioner of Police come and give evidence. And so that was sort of all the idea of people need to see what this thing is, they need to smell it, they need to hear it, they need to see it, so that they know what they're going to lose. All right, so then the election comes along, but one of the other key things I wanted to do before the election was to publish a report. And in that report, it set out, and literally the election was 26th of October. The team published a report 25th of October at 6 p.m. So, you know, you're really cracking the whip there on everybody. But what it did is it set out some of those things that we had achieved. It set out our plan for the 3 years. I wanted to put in there what we'd expended to date, and we'd expended about 5% of our budget. I wanted to be very open about that because, you know, weighing up all the issues. But then the election comes along, it's 26th of October. And interestingly, a few days after the election, the 31st of October, before the new ministry had even been sworn in, the Premier gets up at a press conference and he's asked about the inquiry. And he says ultimately that the government are going into a different direction. They're going to repeal the legislation. And he says that the work we had planned, we had 2 truth-telling sessions planned for Cherbourg, which was 40 witnesses we had prepared, and we were, which was going to be November, and December were going to be our witnesses on Manduraba, Stradbroke Island. Those things can't continue. So this comes out in a press conference. I'm sitting at, I'm not in the office, and I get a call from our comms team, and I thought, okay, this isn't good. And because no sort of prior warning to us. And yes, in the lead up to the election, there had been a lot of commentary. The now government had published a 100-day report about what they wanted to achieve in their 100 days, including things they wanted to cut, things they wanted to do. We weren't mentioned in there, so we thought, okay, we've got a bit of time here. Let's see what we can do up until the early new year. But those comments ultimately led to putting the inquiry on pause for a short time. And as you know, you can't run an inquiry without government support, and really a large part of the work the inquiry does would be looking at the role of government, the documents that government hold, the role of different departments. That's really critical in understanding the impacts. And so for government to withdraw support it makes it non-viable. But a number of events transpire then. So this is on the 31st of October. Over the course of the next 3 or 4 weeks, I write a series of letters to the Premier, the Minister, and the Director General, just requesting urgent meetings. I did have one response from the Minister, which was to have a meeting around the 7th of October, but then she postponed that. Come the 23rd of November, I thought, well, I've got a huge team here who are all literally going crazy. They need stuff to do. We've got responsibilities while the Act still exists, and we need to go and exercise our responsibilities, our duties under the Act. And so we hit the green light again. But being responsible, we knew we couldn't run the big truth-telling hearings because it's really costly. It's a 3 or 4 month preparation period. But we opened our submissions portal again, and we started to engage. We'd sent out actually 400 notices, sorry. So we started to engage with the different organisations who we sent notices to, including government departments. Then I think around a few days after making that announcement, where I think it's the 31st of, well, it's about a week ago now, Still no word from the Premier or the department or the Minister. We're sitting in, actually just filmed a video in my office, and my phone starts buzzing. I'm like, okay, what's going on here? And the Deputy Premier had stood up in Parliament to introduce a bill to amend the Olympics Act. But tied to that bill, and no one knew, was a repeal of the Path to Treaty legislation. So I found out the same time everybody else found out. And we all jump around the computers in the office, and the team's all watching, and some are crying, and it's all happening. It's a bit like a movie. And I said to the team, look, we've got 2 hours, and we're out of here. Because part of the legislation was this, when they moved the legislation, they also moved a really urgent motion that the legislation had to be passed by 11:55 that night. So, no long debates, no consultation, no committees. It was all done in haste. And so, literally said to the team, 2 o'clock, let's call a press conference, and then that's it. It'll be game over for us. Ivan went around and he did his CIA analyst thing and made sure all the documents were organised and all that sort of stuff. We sort of watched the repeal legislation come through, and different ministers were sending me snapshots or photographs of what the legislation said, because no one had it. But in there, it was obviously tied to the fact that once the legislation came into force, we were automatically terminated. And then I think on the last, like I say, this is about 12:30. 2 o'clock, we give this final press conference. We know we're out the door. We'd actually had our offices packed for a couple of weeks, because we thought in Queensland every week is governor and council appointments. And so, there's a process of cabinet sitting and then goes to governor and council. So we thought every Thursday there was a possibility of losing our jobs anyway, but, we held firm on that for a couple of weeks. But ultimately then, and it was sort of, it's at the same time as the minister stands up and starts talking, I then get my first email correspondence from the minister, right? Just saying, we're repealing the legislation, happy to meet tomorrow at 9:30. And I thought, well, do they just want to laugh in my face and hand me my termination papers? But I didn't want a bar of that. But ultimately we go, we have our 2 o'clock, we say goodbye to the staff, and that's it. So, and we get our termination papers the next Friday. They send them through as soon as the governor and council signs off. So that was how it all transpired. And the interesting part of that was when the Premier stood up in that first press conference, he said he wanted to do things in a respectful and decent way in terms of closing down the inquiry. And obviously, the facts, like everything in law, the facts speak for themselves. So that was how it all ended. Now, one of the things I did say when I finished that last press conference was that if the government go on with some low-level community truth-telling sessions, then it's a lack of respect for us, and we deserve what everyone else deserves. And we deserve no less than an inquiry. And I didn't want the government to think that they can run some little community truth-telling sessions across the state and think that was enough, because the truth-telling and healing inquiry, as we've heard from Uruk, is much more than just hearing the history from our own perspective. So those are probably the key things I wanted to touch on during my time before we hand...
I think what might be quite interesting, Josh, if you could talk to our strategy around communications and engagement with all of Queensland and getting media on side early on. That played a really pivotal role in getting our visibility out to community and to all of Queensland. I think from our first opening ceremony, our first and only hearing and session, we had really strong media presence representing all of the major media outlets except for Sky News. But we had even News Corp publishing pretty positive reports and articles about us. But do you want to talk a bit about the strategy around our comms?
Look, I think what really is important is highly intelligent, articulate, really strong black leadership. And, that's what people have seen, I guess, over the course of our work on the inquiry. Thank goodness that we had that public awareness function in the terms of reference. I utilised that point to the complete extent I could. But as I say, setting the tone from the start with the team, our comms team, is every person in Queensland needs to know what this inquiry is, what it does, etc. Having that expectation from the start made sure the team were working to that goal. I didn't want to have to chase our tail in that. And when the inquiry was sort of in pause, we had a huge amount of organisations. I think there was about a dozen churches that came out in a joint statement expressing support. We had different organisations, and non-Indigenous organisations coming out in support. And my motto from the start was this, as the terms of reference says, this is for all Queenslanders. What's the point of telling the truth if no one's listening? And I would continually say that to the team. And so having that process and having that awareness about how do we utilise our communications effectively to engage with all Queenslanders from day one was a critical part of our process. And now that obviously then continued throughout the form, or came particularly relevant over those last 4 weeks, where we'd had developed really strong relationships with the media. We'd developed really strong, we were able to call press conferences within an hour and have every news team there, and engaging in a way which, was effective in being able to tell our own version of what had happened, because otherwise that would have been lost. Questions? Any questions, comments? Yep, far away. I think we've got some mics coming down, and we've got one out the back. So yeah, we thought we'd give you plenty of time for questions. We thought there'd be a few.
Thank you. Fellow Queenslanders over here.
Good. We've got a busy 4 years ahead of us, so.
So you've mentioned the importance of strategy in trying to, I guess, win this war. I would like to know what your strategy is over the next few years and what you see the top priorities for Queensland as of the next few years. But also, I guess, how you're going to go about selling the benefit of truth-telling to non-Indigenous Australians who, I think we all know at this point, probably don't see the value of it.
Look, I think, I just want to take it back to those cases that the stolen wages stuff, and ultimately I'm always trying to convince the person who's making the decision. And I want to do that through the way I tell the story. And it was interesting seeing, I think, Justice Murphy recently talk about his experience on stolen wages WA. And so I prepared all those hearings. That's my work, right? Hearings and witnesses. And it's very strategic about what witnesses you call. And to be honest, there are certain points where I want to call witnesses who are going to cry. Like, it gets down to that level of detail, right? Because I need to emotionally engage the judge in the story. And so that was part of what we did with the inquiry, in terms of we wanted to call those initial witnesses that people could engage with, that someone could sit down and say, you know what, that could be my grandmother, or that could be, the lady who lived next door to me. And this wasn't by design, but the witnesses who came forward and spoke really some real stories of hardship and brutality, but also spoke about the importance of us being unified, us coming together. And that message of unity was a key part of what we wanted to achieve at the inquiry. But look, I think, and this is all you can do. When people can see something, it's much easier for them to understand it. And that's what the inquiry was able to achieve. I think if we talk in concepts and ideas, and it is really hard for people to actually understand how this affects them. And a lot of the commentary that came out in support of the inquiry post was, from the non-Indigenous community, from the Courier Mail and from the Australian, the people you wouldn't ordinarily expect to support us, was, what's wrong with telling our truth?
Thank you. Firstly, I just wanted to say thank you. Us Queensland Mob really appreciate your strength in the past few weeks and how appalling the LNP kind of handled that. So, first, I want to say thank you for all the hard work that you've done and will continue to do. Us blackfellows really appreciate it. I guess my question is kind of what's next for us Queensland mob, and is there, you know, a kind of a lesson here or something we can take away? Is there a way to do these processes where we aren't so vulnerable to, you know, party politics and the government of the day, you know, constantly repealing process that is made in previous governments? Is there, you know, a different way? Yeah.
Look, we're in the long game. You know, we can sit and we can wait and we can strategise and we can develop things. So we don't have to do stuff overnight. But I still think the message from the Uluru Statement's important. Like, nothing has convinced me otherwise. I still think constitutional change is important. I would have had a different proposal. You know, as a lawyer, I'm always looking for a power to start a case. You know, I've got to take the Racial Discrimination Act and like bend that around and make that work. But, you know, having something in the Constitution, having treaties, having a Bill of Rights, as a lawyer, as a litigator who likes suing government, that gives me a lot of power to start cases. So, you know, I still think the message from Uluru Statement's important, and I still think constitutional change is